Thank you, Kate, and thank you to the Board of Affinity for the invitation to speak today. The topic that I gave the organisers was law and society, which gave me plenty of room to move. Law can broadly be seen as the body of rules and compulsions that regulate and control society. But I think that's probably a limiting and unnecessarily formalistic analysis. Let me turn this off. It's off. Good. Law's place is fundamentally consensual. The society of which the law exists must consent and admit to the authority of that law and of that state as society's political embodiment. Ultimately, that consent is built on trust that organs of power will faithfully exercise that power for the common good, and that power will be exercised by reference to values. The consent to which I refer is the broad consent to the structures and institutions of power and regulation that exist in the orderings of society. I do not suggest that every convicted criminal must consent to his or her incarceration. But what there will be, generally, in the milieu from which that convicted criminal comes, and indeed in the heart of that same convicted criminal, an acceptance of the structure that has placed him or her where he or she finds themselves. Thus, law and society cannot be understood without a consideration of law and values. And that is what I wish to talk about today, and that is law and human values. It may strike you halfway through the talk or earlier that this is an idealistic description of a perfect society, but it's not. It is to identify the values that must exist in any civil society, to give strength to that society, to deal with the necessary political or the inevitable political traumas that all societies undergo at some point. Because law at its very foundation is conceived and derived from values. And those values inform and underpin each individual's understanding and expectation of how power is to be exercised by and against her or him at a private and a public level. They likewise inform how society responds to the question of how power is to be exercised, organised, distributed and controlled. Values find their expression not only in formal law, but also in societal expectations, behaviours and actions, which may in time also come to be reflected or incorporated within the law, but which in any event do not require formal legal expression for society to understand their correctness or importance. This is not, however, to say that these values, or indeed that the laws, rules, principles and expectations derived from and reflecting such values are merely specific cultural manifestations, or that they are culturally or jurisdictionally derived. It may well be the case that such values form part of a culturally specific heritage, but they are far more than that. They transcend cultural boundaries, and they lie at the heart of every individual and at the heart of society as human values. These essential human values are a rejection of unfairness and an insistence on essential equality, a respect for the integrity and dignity of the individual, and mercy. Each goes to the core of what we understand humanity and the individual to be, and what is expected when power is exercised by or against individuals. Each value in turn finds expression in the specific rules, principles, precepts and norms developed by society and by the law. The law in its creativity and flexibility has drawn upon these values in numerous manners and numerous forms. I will concentrate in my short time today on what I will call public law as opposed to private law. Public law being the law of attending constitutions and the exercise of government power. The concern of public law to prevent the exercise of power which is arbitrary, capricious or unreasonable, for example, can be seen to reflect a concern with rejecting unfairness. It can be seen with a concern of the reasonable expectation that individuals, that each individual has who is affected by power will not have that power exercised against him or her in a manner that fails to respect his or her dignity and integrity. For another time, the same can be seen to reflect the concern of private law to prevent unconscionability and to deter behaviour, including in commercial law, that is antithetical to honest, reasonable and mutually beneficial commercial behaviour. There is, of course, an important balance to be struck in this respect. Legal systems and societies cannot be built or sustained by reference only to what might be called pure values. Neither, however, can societies be built on strict rules alone. Rather, a distinction or a balance must be drawn between rules, principles, or precepts, norms and values. These are not clearly identifiable separate vehicles, but expressions along a gradation of particularity: rules, principles, precepts, norms and values. And the proper balance to be struck must recognise the requirement that rule and principle conform to moral standards as the gauge of the law's flexibility and as its avenue for growth to accommodate changes in the values in society without the need to change the rules. And care is required not to confound law by the suspension of rule and principle and a drift into a void of sentiment and personal intuitive benevolence. Let me talk about the control of power and public law. Public law encompasses various areas or subjects in which society as a whole has an interest and where a form of state power is exercised. This includes not only constitutional and administrative law and the law concerned with the organisation of legislative and executive power, that is of Parliament and the government, but also areas such as criminal law and the law of insolvency. In each area of public law, power is distributed, exercised and controlled primarily by reference to text, either a constitution or a statute. But those texts are in turn to be read and understood by reference to the organised values that surround them and to the purposes and aims of the texts in the social and political milieu of their creation, including a consideration of how people should be treated in the exercise of power in a just and decent society. Now, this is not about being nice. Rather, it is about how those who are subject of the exercise of power in a civilised society should be entitled to expect that the lawful exercise of power involves attributes or characteristics that recognise and reinforce human dignity and integrity, and that reflect the high trust that society has placed in those people with public power to exercise it lawfully and for the common good. Such considerations which inform all aspects of public law include the reasonable expectations of women and men in their lives, the notion of a civilised society, meaning a just civil society in which there is a shared and expected reciprocity, and freedom from the exercise of arbitrary and unreasonable power. If I have time later, I will try and remember to go back and read you a passage that a great American legal philosopher wrote in the 1920s, a man called Roscoe Pound. I'll come back to that if I can. Let me turn to an example from this country, from this state. The influence and place of values can be seen in the concerns expressed in maintaining the integrity of the judicial process. That is, the necessary separation and separate integrity of the judicial branch of government. In a case called Cable in the early 1990s, mid-1990s, the High Court of Australia was faced with an act of state power that purported to permit or require preemptive imprisonment. Mr. Cable, who had been convicted of a violent crime. He had killed his wife and had been convicted of manslaughter. As he approached the end of his sentence, he sent letters from prison to individuals, mainly her family, that caused it to be thought that at the end of his sentence and upon release, he might well commit further violent crimes against them. An Act of the New South Wales Parliament was passed that provided for his continued detention by order of the Supreme Court, upon the Supreme Court being satisfied of certain conditions, none of which were conviction of any crime. The argument of one of the great counsel in Australian legal history, Sir Maurice Byers, on his behalf, reached into the very foundations of civil society. He said the statute was not a law, but rather, in substance, an order by the Parliament to the court to imprison Mr. Cable, and that the New South Wales Constitution required the continuation of a working assumption that the courts were independent. Aspects of all Sir Maurice's arguments were woven into the reasoning of the majority of the court. Justice Gaudron's judgment, which makes the best reading, if I may respectfully say so, her starting point was the constitutional structure of an integrated judicial system. In such a judicial system, there was an assumption of the equality of justice in all courts. Justice Gaudron and the other judges in the majority were concerned with... were concerned with much more than simple structures of government. This was not a turf war between Parliament and the courts. The court was concerned with freedoms and liberty upon which Australia's whole system of government is founded. Because the judicature, the judicial system, is vested with a form of power that is distinct and different from executive and legislative power. It is based on pre-existing law, and as part of its essential fabric, that the exercise of judicial power is required, constitutionally required, not statutory, but constitutionally required, to be fair, equal and just. And that reaches back to the rejection in modern society of inequality of status that so pervaded and founded the ancient world. And to the recognition that developed hundreds and hundreds of years ago in a religious context, but has long left that one man or one woman's soul, however lowly they were born, was the spiritual equal of the soul of a king. And the forging of the place of the individual and the recognition of her or his human dignity lie at the foundation and the root of our conceptions of fairness and equality. They are the features that engender consent, trust and respect of society in the administration of justice in its daily contact with people. And that daily contact can often be productive of distress, a sense of abject failure and crushing humiliation. And so what the court was doing in that case was prohibiting giving functions to a court that were incompatible. Let me leave that constitutional territory with a final comment that it was the protection of those who wielded judicial power from the notion that they were at the direction of the Parliament or the executive, required to behave in a way that was legally unfair, unequal and unjust. The presence of the values that I've spoken of is also demonstrated by the pervasive legal notion of natural justice or procedural fairness. Those concepts are coherently structured around certain rules and precedents. So you have that structure of form and stability in the law, but at the heart of all those rules is one simple conception, and that is the simple notion of fairness or a lack of unfairness. And the major case involved, or that identified that in the last 30 years, an immigration case called Kiowa and West, two great judges of this country, then Justice Mason and Justice Brennan, both later Chief Justices, saw that fairness was one saw fairness as part of the common law that limited the statute. The other, interestingly, saw it as part of the statute itself. The difference may only be of interest to lawyers until one recognises this. If the requirement of fairness is within the common law, it draws its source from some well of fairness as an incident of the general law. If the requirement of fairness lies itself within the sovereign command of Parliament, it implies that the necessary character of and a limit upon that lawmaking power by Parliament. Of course, unfairness can be a matter of debate. It will often be affected by the context and the statute from which it comes. But in essence, it is an enduring human response rooted in a civilised society's expectations of equal and fair treatment of individuals by organs of power. Syllogistic reasoning expressed in language seeking to define an operative rule will generally be inadequate to express why an exercise of power is unfair. Often the difficulty of explaining why arises from the fact that the exercise of power must be assessed in its human dimension, taking into account an evaluation of sometimes indefinable characteristics and nuances of the human condition. Put bluntly, essential in many analytical reviews of the exercise of governmental power is the partly legal and partly human response to the facts. Is this how people should be subjected to the power of the state? It is an expression and reflection of the importance and enduring place of human values in the development and the application of public law. Equally important, however, is for the law to strike a balance between rules and values. The balance must itself take account of the particular objects and subjects of the area of law one is dealing with. Let's take the criminal law. It is an overarching object of the law that the legal system be fair, equal and orderly. But fairness, equality and orderliness in the decision as to whether someone is a criminal, has committed a crime, immediately raises the notion of certainty. Society's rules must minimise the distress and uncertainty and confusion of parties who are to be accused of heinous conduct. Thus, in the context of criminal law, and particularly at the point of ascertaining criminal liability, the operation of the law should be as certain and clear as possible without interpretive, evaluative assessment. You either breached or did not breach the law. If the interpretive choice is between making a value judgment and applying a rule, a court exercising criminal jurisdiction should prefer the rule. At the point of sentencing, however, certainty gives way to human equality, humanity, and regard for the individual. Once the criminal liability is established, the importance of evaluative assessment by the court reaching a just punishment is what is to be recognised. And without going through cases that I don't have time to, the history of the High Court's jurisprudence in the last 15 to 20 years, when it has been dealing with criminal sentencing, is to reject time and time again any mechanical rule-based formula to identify certainty and predictability in sentencing, in favour of an evaluative, intuitive response that seeks to individualise the punishment to the just sentence for the individual. And that contrast between how the High Court approaches criminal liability and criminal punishment perhaps best reflects the balance and context of rule and value in the operation of the law. This very brief insight into the place of values in aspects of public law, constitutional law, administrative law, and criminal law illustrates, I hope, how law and its administration is rooted in society and the values that sustain that society. It's a balance between rule and evaluation, between rule, principle, and values. And at all times, the interplay between those rules and those values lies at the heart of the society understanding that it is society's law that is being administered and society's values that are being vindicated. Thank you.